minutes from the meeting of the Joint Judiciary Committee held on October 16th, 2023.
You've heard the gentleman's motion. Is there discussion? Hearing none, all those in favor of that motion, please signify by saying aye.
Aye.
Those opposed, please say no. Ayes have it. The minutes are adopted. I'm going to take some levity from the chair briefly to thank the folks at Independence Hall for hosting this committee. I know it's been busy. What an incredible piece of history we have here, and to be able to celebrate it today. And hopefully we can live up to the history that is underneath our feet. And I also like to give a special thanks to all of the legislative staff. There's a lot of moving parts here, so I know that the chairman and I are very appreciative of that work, as are all the members, because it is a lot of work, and we certainly appreciate that very much. So, with no further ado, we'll get started with the program that we have today. We have two parts to our program. The first is a presentation on Social Care Network data privacy, and our presenter is Aaron Gregg. So, Mr. Gregg, we'll just have you step to the podium here and present, and then at the conclusion of your presentation, we'll allow the members to ask some questions if you're okay. Take it away.
Hello everybody, my name is Aaron Gregg, and I'm the honored CEO of an organization called Find Help. And I'm actually a little relieved that there aren't slides today because it's easier just to have a conversation about this subject. So 26 years old at the time, and I became my mother's legal guardian. I grew up about 3 hours away from here in a small town where she caught a rare brain disease called encephalitis, which she went from working, she was a janitor at the local community college, to being permanently disabled due to the potential of seizures and things like that. And not really being prepared for this, went off to college, got my first job, and got a phone call from my dad when he got sick, saying that he couldn't take care of her anymore. And so for the last 21 years, I've been her legal guardian. Now, she lived with me for a very short period of time because she requires 24-hour care, and I'm happy to say she's doing well. We visited her on her birthday, which was on Saturday, and she enjoyed her Diet Dr. Pepper and some snacks that she shouldn't have been eating. But over that time period, I learned a lot about what people need. And so 13 years ago, I set up a software platform called Find Help, which is a search engine for social services that people use to find and apply to social services electronically. And over the last few years, we're adding about 1 million people to our network every month, about 34 million in total. And I ran some numbers last night just to share a little bit about why this is relevant to data privacy. So far, just in our system alone, we've served about 256,000 West Virginians. Now, these are either people in need that are getting on their phone and searching for the nearest food pantry or for a housing program, or it could be their social workers that work for West Virginia University Health, which is one of our clients, or some of the other organizations, including the Medicaid managed care health plans that use our software for referring people to social services during their time of need. Or lastly, it could be some nationwide organizations that serve West Virginians, like the AARP Foundation or the American Diabetes Association. And so, why does it matter? Well, 14% of the population here has engaged in our network, and probably more than that have engaged in other networks, if you add the two together. What we see from the data is about 32% are housing related. They're coming from cities that you might expect, bigger cities and counties. In fact, more people have searched in October than any other month so far. We're seeing probably a 260% increase in food-related searches. Part of that's probably related to public health unwinding. And probably the second fastest growing is assistance paying for utilities. So people are searching from all over the state. In fact, Parkersburg 26101 is the most active zip code in the state. So why are we here today? Well, the interactions are growing exponentially in electronic systems like ours. And it isn't just the poor who are engaging. These are parents, children, helping their parents really navigate this. And life throws us all a curveball. So people's hardest moments in life are now being digitized in a way that they never were before. Typically, 20 years ago, people might go to their church or they'll go to another program, and it was offline. It was kept private. And now, so if people's most sensitive data is accessible by friends, family, and coworkers, it could hurt them in the future. Now, I'll say you probably don't get a lot of businesses coming here and asking you to regulate their industry. I'm assuming probably not. But this is really an opportunity to get ahead of a potential problem before it gets bigger. So I'm going to walk through a couple of really quick examples. Imagine I'm Joe, and I'm sitting with a social worker at a hospital system. I'm leaving the hospital system because I had hip surgery. And I could either recover in a nursing home or I could recover at home with my spouse. Well, I'd rather recover at home, but maybe there's 5 stairs to get into my house, which make it hard to get up those stairs. And what ends up happening is health plans end up covering recovery in nursing homes when they could have helped them stay in their home. But the person couldn't afford to build that wheelchair ramp. So what's happening is that the referrals are being recorded in systems like ours. Now, if you're working for a health plan, you're a HIPAA-covered entity, and when somebody signs a consent in your lobby of a hospital system, that system is accessible for the purposes of administering those services. But where it's a little bit of a gray area is that what if that data is accessible to a volunteer at a church or a volunteer at a housing authority that isn't covered by HIPAA? And that's where it's just a little bit more of a gray area. And that networks like this are becoming larger and larger and larger. And there's opportunities to prevent people from just looking up friends, family, ex-spouses. And the way that we think it should be governed is through what's called a per referral consent. And that is, you just simply ask somebody, are you okay if I refer you over to this church or to this housing program? And you record that consent in a checkbox. It doesn't require a signature. It simply is a way of attesting that that social worker or that care coordinator recorded that consent. And what that is used for is to prevent people that shouldn't have access to it from getting in there. So that's a high-level overview, really, of the core principles. One, we think that when you define a closed referral network, which is happening in every state across the country right now, provide a definition for it, good practice to ask for a per referral consent, and then, we don't think that this type of data should be sold. I think we've all seen what happens with advertising data that follows you around the internet. In other states, there are bills being introduced that prevents the selling of this very sensitive data for the purposes, without that person. People ought to know about it. And so, in closing, I won't take the whole time today, but we believe that the ability to get ahead of this now can prevent bad things from happening in the future. And protecting people's sensitive data it is something that we have an opportunity to get to now, because the exponential growth of this data, even in West Virginia, is happening everywhere across the United States. And we want to put some controls in. We think putting some controls in place would be a good idea prior to something bad happening in the future. So with that, I'd be happy to take some questions if there are any.
Delegate from Jackson.
Thank you, Chairman. I got a couple of questions. First, you said each person has to sign the consent form. They can't just say, I need help and to some agency, so they have to sign a consent form for every referral?
No, they do not need to sign a consent form. They just have to give verbal consent. So as they're sitting with their social worker, they simply say, yes, I am giving you verbal consent to share my data with this food pantry, but they give that verbal consent on a program-by-program basis.
Okay. So you said how would be better if they did by program, just have one consent one time, it goes in a system somewhere, or what, or how would it work?
I think the better way to do it is to ask the person, maybe the person lives in a small town and they're okay being referred to the housing authority, but they're not okay being referred to the church that runs a food pantry because maybe they go to that church and they don't want their situation being exposed to them. So by asking them per referral, a verbal consent, that allows them to keep their name not searchable out of the hands of maybe the parishioners that they go to church with. So it is on a per program basis, governed at the social worker level by just having a conversation with them.
Okay, second question, you said your most hits are Parkersburg. And I went to the meeting with Chairman Patrick in Parkersburg, and we had a lot of police officers there and different people. Parkersburg has the most beds for rehab in any place in West Virginia. They've got a homeless problem right now. You think that's what it is or what?
I think that would explain it. I was having a conversation this morning that people are coming from other states to get services, and that is my understanding as well.
Okay. It kind of makes sense what you said, Parkersburg had the biggest. Okay, thank you, Mr. Chairman.
Senator from Jefferson.
Thank you very much. Can you tell me how this would affect the HIPAA-covered entities?
Sure. It has no effect to HIPAA-covered entities because when I go to my local clinic, I sign something in the waiting room that basically states I give my doctor permission to use my data for the purposes of administering those services. And so the good news is that for HIPAA-covered entities, they're already governed by HIPAA, by audits, by all sorts of protections that are in place. And that allows employees of that hospital to look up Joe and see his history because of the consent that Joe signs when he comes in to check into either the emergency room or to see his doctor. So there's not a big impact there. Where this becomes an issue is for those non-covered entities and the governance around who can look Joe up if Joe hasn't given that organization explicit permission.
Thank you.
Senator from Greenbrier.
Thank you, sir, for being here today. Now, as you collect all this social care data, you may, in the future, at a point in time, whenever it may be incentivized to sell that data. Now, what could be some of the implications after the data is sold, the social care data is sold?
Well, this is one of those areas where it could be done in many ways. I mean, it could be, if bad actors get a hold of the data could be used as lead generation, for example, payday loan companies or extended warranties or other things like that. So hopefully rates aren't set by, health insurance rates and other things won't be set by this data in the future. So we think it's best to prevent that sale of data in its infancy, and while this industry is in its infancy, to prevent that from happening once it goes outside the walls of the referral networks like ours. And so there's probably other reasons. For example, it's possible to bundle this data with other data for the purposes of risk stratification. A lot of times, Medicaid managed care plans will want to know who's struggling so that they can get ahead of it. So the purpose might be noble there. We think the sale of data crosses a line that, especially without somebody's explicit permission.
And would that initial check at the doctor's office, would that be the complete consent forever for that patient?
Well, it depends on if that's written into the consent, and that's typically governed by a state-by-state basis. So in other states that are having this discussion now are bundling the per referral consent, and they're also addressing the sale of data based on the local laws of that state. But what we believe as a company is, we will, our commitment is that we won't sell data, and right now it's just the good faith of a specific company, and we think with some legislation that, it lives on 10, 20, 30 years, 40 years from now.
Thank you, sir. Thank you, Mr. Chairman.
Chairman.
Thank you, Mr. Chairman. Mr. Gray, just following up on the good question by the Senator from Greenbrier. It looks from your materials that your operations nationwide have other states enacted legislation that you could point us toward as a model for the kind of regulatory structure you're talking about?
Yes, the first state that has enacted legislation is New Hampshire, a live free or die state. They actually passed a constitutional amendment to privacy in 2018, and in keeping with that, they passed legislation that requires full referral consent, and it passed without a no vote. Both houses, and was signed by the governor 2 years ago. There's been other legislation that's been introduced, and varying legislature. We're following that as it goes, but it looks like the states are leading the way. We haven't seen a lot of action from the government side, but definitely in the early stages of this type of legislation.
Thank you very much.
Mr. Gray, question. So who or what entity determines, I'm looking at this slide here. What entity determines the services at present that the referrals are going to be made? To whom the referrals are going to be made?
Great question. Typically these networks are, they could be statewide, but they also could be a hospital system or a little bit narrow. So the answer is it depends. So a hospital system that's trying to address diabetes would have a smaller number of organizations within their referral network, and they'll define it that way. But a statewide organization that is focused on job placement or something like that would leave it to entities that are related to finding a job. So the short answer is it depends.
What information, just by way of example, would again at present, what information would the food pantry receive about the individual that came in to find housing assistance?
Sure. Well, there's a couple of ways. One is food pantry will typically ask for the name, a little bit about the situation, demographic data primarily, and they're usually interested in the address because food pantries are usually situational to a current location. A food pantry isn't going to have detailed healthcare information, as opposed to other programs which need more of a background on their healthcare information, would have more details on that.
Well, you covered HIPAA a little bit. I'm just curious, and the senator from Jefferson had asked about it, HIPAA covered information. So is any information that's leaving the HIPAA covered entity that's going to the referral network, is there information that cannot be released?
That's an outstanding question. Yes, because let's say, for example, somebody is, maybe that food pantry is in a relationship with that hospital system where they're doing some extra counseling based on a disease they have. Well, by the nature of the referral coming through that program, they can absolutely infer that Joe has diabetes or has HIV or addiction issues or whatever the case may be. And I think you're enunciating why the one-time consent is risky, because it really is about open lookup. So the illustration you're seeing on the left-hand side, open lookup works great if I'm in a small city and if I were to show up to an emergency room unconscious, I don't mind if the emergency room that's on a different electronic can look up and see my information. But it's that exact scenario that you're talking about where some of the health information could be sent over to that food pantry. And what you really want to limit is who can look up Joe. And in that case, Joe said it was okay, because remember, he recorded the verbal consent for that food pantry. But looking up Joe on other parts of people that were in that same network, those green circles there, or ovals, you run the risk of somebody looking up Joe who really doesn't have permission. So you can technically prevent that from happening by requiring that verbal attestation and that verbal consent, because that way, only if it's a network of say 100 nonprofits, then only the 3 that Joe said was okay can query Joe and see Joe's history.
Right, but coming at it from, last question, coming at it from sort of the other direction, if it's a per referral consent scenario mapped out on the slide here, you have somebody that presents at a healthcare facility. Their request is centers around housing assistance. Perhaps they need other services, but if they're coming in and saying, I need housing assistance, and then they get to the housing assistance and then realize they need help finding food bank, would they go back? Or would the housing assistance refer them from there?
That's exactly right. So, and this happens all the time. So if Joe then goes to the housing organization, because he was referred there, well, that housing organization, and most of the referral networks allow this, can then refer to other entities once they learn something new about Joe. They may find out that Joe really needs a subsidized counselor, or he doesn't have consistent transportation and he needs a referral to a transportation organization to get to work. It's additive. So I mentioned that example of, originally at the hospital, Joe gave 3 organizations the ability to look them up. Well, that might grow over time as Joe interacts with those organizations. And so after sitting down with a social worker he builds a trust with, she may refer him to 3 more. And then now, 6 entities have access to see Joe's referral data.
Further questions? Mr. Gray.
Thank you, sir.
Appreciate you being here.
Thank you.
All right, shifting gears, our next presentation comes to us by our old friends here, who's got a promotion. Chief Judge Daniel Greer is joining us today to give us an update on the Intermediate Court of Appeals. Thank you for being here, Judge Greer.
Thank you for having me. Appreciate the invitation to be here. Always like being around the legislative branch. I was talking to the senator from Marion before we got started. We were talking about the last couple of times we had been here at this facility. The last time was 21, I believe it was, when we were going around the state doing redistricting hearings. And the previous time before that was in 2013 when I worked for the Attorney General's office, and we had a meeting, last time the interims were here, I think, and I had a meeting with the Post Audit Committee. So as of today, I've managed to be in this room for the executive, legislative, and judicial branch. That's pretty cool. I like that. But when I go to judicial meetings, I like to wear the House of Delegates golf shirt that Jeff Bellings gives me. All the judges kind of give me funny looks when I show up wearing the House of Delegates. Glad to be back amongst my legislative brother. As a court, the Intermediate Court has been in existence now for 16 months, a little over 16 months. We came into existence officially on July 1. So just wanted to take this opportunity to sort of report on how things are going and what's happening there. We recognize that we are absolutely a creature of the legislature, so I think it's entirely appropriate to let you all know how things are going. It's also interesting to see what happens with this court. As we were the 43rd state to have an intermediate court. None of the other 42 before us are set up like us. We are a example of one in terms of how we're set up as an intermediate court. There's one other state that has a statewide intermediate court with 3 members, that being Nevada, but the jurisdiction, the way it's set up is totally different. So it's been interesting to see how this plays out. And also, before I get started, I want to thank both my colleagues, Judge Starr and Judge Lawrenson. It's been excellent to work with both of those gentlemen, and we have different opinions at times, but we've always gotten along professionally and courteously, so I want to extend my thanks to them for the things that they've done. As we go through these different, I think you have the materials in your packets here, but if you turn to the second page there, since we've been in existence, as of October 30th, we had received 809 total appeals filed in our courtroom. Obviously more since then, but as of that date, 809. When you break that down, and considering the first month, we got no appeals because our jurisdiction was for orders entered after July 1, and there's 30 days after orders entered that you have time to file a notice of appeal. So we literally got no appeals the first month. So if you break that down by month, that comes out to an average of about 650 a year. And we think that's going to be a little higher than that because it tends to be a little slow in the early end with some things going on with comp. So we think as we settle in, we'll probably be closer to 750 or so appeals a year, but that's where we're at. But also notice on that page, the percentage of appeals in the different case types. Our 4 major case types that account for 99% of our cases are administrative appeals, civil appeals, family law, and workers' comp. And as you can see, 15% administrative law, 31% straight civil, 23% come from family court, and 31% from the comp system. Page 3 of your materials there, just sort of comparing our numbers based on what we in the court system kind of estimated our caseload to be based on looking at historic numbers. And we estimated civil to be between 15 and 20%. We're obviously a little higher than that. Administrative between 10 and 20%. We're right in that range. Workers' comp 37 to 45%, and we're a little lower there. And the main reason of that, there was some things that happened at the board of review with some office changing of computers and software where the spigots kind of shut off there for a month or two in the spring. And that accounted for a somewhat lower number both of our caseload and the percentage of our cases currently from comp. And then we're at 23% of family law, which is just a little bit less than what we estimated there. Going on to the next page, this is interesting information to see where the appeals that we're receiving, where they went before our court came into existence. And 38% of our caseload, that being our family law appeals and our administrative appeals, before our existence went to the circuit courts, and the circuit judges handled those appeals. So we were not an additional level of appeal, but the review switched from circuit courts to our court. And we think that's tremendously significant for a couple of reasons. First of all, I think if you talk to any of your circuit judges, I don't think any of them are going to complain about not having a big enough workload. And if you talk to your circuit judges at all, you know they're getting overwhelmed with abuse and neglect cases involving the drug epidemic in our state, other cases. And while I don't think this can fairly be said to be a huge workload off any circuit judge, I think that the fact that 38% of our workload is taking work off of the circuit judge level is a positive. A lot of the administrative appeals, in particular the family law appeals, when they went to circuit court, there was a 30-day window for those to be turned around. The administrative law cases did not have such a timeline, and just from the necessity of getting priority work done, you know, if you practice law in that area, that a lot of the administrative appeals were just of necessity the lowest priority for the circuit court judges, and a lot of them would linger just because the circuit judge didn't have enough time to get to them with the more pressing things. So we think that that's a significant thing to look at. 31% of our cases came before us to the Board of Review. If you remember the legislation that created our court, the Office of Judges was also eliminated in the workers' compensation system. And now the first review from the legal system is from the Board of Review instead of the Office of Judges. After the Board of Review, then the appeal is to us, and after us is to the Supreme Court. So again, there we were not a new layer of review, but we replaced a layer. The Office of Judges was eliminated, the Board of Review was shifted down, and we took that first level of appeal. And then the straight civil cases, those are the cases in which we are truly a new level of review and an appeal which didn't exist before. Only in 31% of our current cases are we truly a new level of review that didn't exist, and those previously went straight from the circuit court to the Supreme Court of Appeals. In terms of oral arguments, we've heard oral arguments now in 57 cases as of this fall term. Last fall, because of the cases waiting to become mature, we only heard 2 oral arguments. We heard 28 in our spring term, and we heard 27 in our fall term. And we expect going forward it will probably be around 30 or greater oral arguments every term. That generally comes out to be about 10% of our cases. And every case that's filed with us, once it becomes mature, in other words, when both parties have filed their briefs and all the written materials are considered, we function exactly as the Supreme Court does in that regard, that we meet to review the case and make a decision about whether it will be decided on the written materials or whether we will hear oral argument. And that's worked out to about 10% of our cases are orally argued. As I'm sure you're aware, one of the things the Supreme Court did when they were setting up our court system, was establish remote courtrooms in Grant County, Lewis County, Morgan County, Raleigh County, and Wetzel County. We do not travel to those locations, but those are locations where litigants can choose to go to argue before us. Oral argument is held via closed circuit video technology. Those were done at a convenience to those litigants. For every case we set for oral argument, our clerk will notify the parties and ask them whether they desire to argue in one of the remote locations or at our courtroom. And that's totally up to those parties. And certainly, those of you that have had the privilege of driving to Charleston from the eastern or northern panhandles where we're at now can understand that that can be quite a distance and quite an expense. So if you can save some time from going from here to Charleston by going down to Wetzel County, that can certainly be a convenience and a benefit. To be honest, we're not seeing litigants take advantage of those opportunities as much as we would like. The perception out there that we're trying to combat seems to be that there is some advantage to coming to Charleston to argue in person. We've had cases before where one party had indicated they were going to argue in one of the remote courtrooms. Then they found out that the other party was driving to Charleston, and the response was, well, they're going to Charleston, I'm going to Charleston. And so they both come to thinking that there's going to be some advantage. There really isn't. I mean, there's no advantage at all to spending the extra time and money to drive to Charleston. You have just as much interaction through these remote courtrooms as we do in person. So to the extent that you have conversation with attorneys and litigants in your areas, that's the word we're trying to get out. These remote courtrooms were set up for the convenience of our citizens and to save them time and expense and attorney's fees and all those things, and we really encourage those to be used. On page 6 of our materials, just a little picture of a Raleigh County satellite courtroom that's indicative of these facilities. And these are fairly small rooms in these courtrooms, just enough space to have a place for both parties to be seated at a podium, and then the video screen where they would see us and communicate with us. Anytime an argument is held at a remote location, we've contracted either the deputy sheriff, the sheriff in that county, or the state police, so that we always have a police officer present when we have any of those arguments. As you can see, those often would be family law type of appeals, so we wouldn't want that to be parties to be there unsupervised. So there's always and security there. On the next page, you see actually us holding an oral argument with all of the litigants in Raleigh County. That argument there happened to be in Raleigh County. You can see on the video screens that both the petitioner and respondent there are around the courtroom in Raleigh County, and we're hearing those arguments there. So we've also held arguments where one party is in one satellite courtroom and other parties are in an additional satellite courtroom. So we can do any combination of either present in Charleston or all at the same remote location or all at different remote locations. We can handle any of that technology. So we hope that more people take advantage of that. In terms of recusals of judges, our system is a little different than the Supreme Court. Supreme Court justices recuse themselves and have the ability to remove themselves from cases when they feel it's appropriate. We do not have that unilateral prerogative. If we feel that there is a case that for whatever reason we should not be sitting in, we have to write to the Chief Justice of the Supreme Court and state our reasoning for that, and the Chief Justice will tell us whether we can be replaced for that hearing or whether we're to sit there. So far, we had 7 cases where one of us has been recused in that manner. And we've had 6 circuit judges sit in on those 7 seats. Judge Howard from Capital County is the lucky judge that's got to do that twice. But so the Chief Justice of the Supreme Court is the one who tells us whether or not we will sit or be replaced from those arguments. In terms of our decisions, as of November 2nd, and these numbers have actually changed since then. As of November 2nd, we had issued 315 memorandum decisions. There's been 4 more added since then, so we're now at 319. We've had 21 signed opinions. Typically, although not always, signed opinions are reserved for the more complicated cases, particularly when we feel there's a new point of law that's being established. have signed opinions that are specifically authored by one of the judges the same way that the Supreme Court does. Memorandum decisions are authored by our staffs and submitted without specific authorship to one of the judges. So far, we've issued 319 memorandum decisions. As of today, we've issued 21 signed opinions. One more has been issued since November 2nd, and we expect about 10 or 12 more this week, so that'll be in the 30s by Friday. And beyond that, we've had 154 cases that we've disposed of on some issue other than the merits of the case, such as lack of jurisdiction. One of the parties didn't complete the documents necessarily to perfect the appeal, or if a case is, oftentimes a case will be settled and the parties will withdraw the appeal. So we've had 154 cases disposed of in that way. So our current total, to give you the next page, our current total is 495 cases that we've disposed of, either through opinions or a dismissal or something other than the merits. Of that amount, so far 84 of those have been appealed from our court to the Supreme Court of Appeals. And that rate comes out to a 17% appeal rate. And when you look at appellate courts in other states, generally that number tends to be closer to 10%, and we expect it eventually to be closer to 10%. As we're a newer court and everybody's sort of waiting to see how the interaction works between our decisions and the Supreme Court, we think that number might fluctuate some. But in just about all of the other states that have an intermediate court, that rate tends to be around 10%. Just the next page is just sort of interesting. On our workers' comp decisions, it's just sort of interesting because we have the numbers. If you'll notice in the footnote there, when the Board of Review handled those cases, they kept statistics on what they did with those appeals. 84% were affirmed, 14% affirmed in part, remanded in part, 2% reversed. And it's kind of interesting when you look at those workers' comp cases that we've decided this year, our numbers are very close to that. 86% affirmed, 1% affirmed in part, 5% reversed, and 8% vacated. The workers' comp cases are very fact-heavy. Most of the points of law in comp cases have already been resolved over some issues. And as an appellate court, when it's factual issues, we're very deferential to the court below. We typically don't mess with factual findings unless they're clearly wrong. So it's kind of interesting to see the percentages that we've had in those cases versus Board of Review's work. Family law I want to talk about a little bit. One of the most significant things that I think that will come from the intermediate court is the effect on the development of the common law in West Virginia, particularly in case decisions, particularly in the area of family law. If you'll notice, in this calendar year of 2023, so far we have issued 65 written opinions and decisions in the family law area. Those have been signed with memorandum opinions. If you go back to 21-22, or excuse me, if you go back to 2021, which was the last full year the Supreme Court had to issue those decisions before our existence, the Supreme Court issued only 22 family law decisions in the entire year of 21. And the reason is because they were the second level of appeal coming from the circuit courts. And if you think about family law, these are not corporations, these are not insurance companies that have a bunch of money to be litigating this stuff. So it might be common for the litigants in those cases to take one appeal. It becomes less likely that they appeal to the second level. In that case, which was the Supreme Court. So not a lot of those cases made it to the Supreme Court. It's not because the Supreme Court was ducking those decisions. That's the only cases they got to decide. That's the only cases they had in family law. And just by the way we exist now as the first level of appeal, we're going to get a lot more of those cases to be able to decide decisions. And what happened previously when these cases were heard and decided by the circuit courts, those were never published and made available on a statewide basis, nor were they authoritative on a statewide basis. And what did happen is that the results of those decisions were inconsistent. In other words, the circuit courts that heard the family law appeals in Mon County might come to entirely different conclusions than the circuit courts that heard the appeals in Mercer County. or Berkeley County might be different than Kanawha County, and they in fact were. And so what we had is we had an inconsistent system of appeals regarding family law, so that you had circuit courts throughout the state making decisions differently on the same point of law. So we had an inconsistent development of that body of law. And because of that, we found that and I don't have a percentage here, I know the percentage, but I didn't put it in here, but the affirmation rate of our family court decision is the lowest in terms of the subject matter. And it's not because, it's not the fault of, or don't take that to be an indictment of the family court judges, because it's not. What that is a result of is there's inconsistent law being developed throughout the state, and how things are being decided in one part of the state is different than it is in another. And we're going to have to pick one or the other, and one of those are going to end up being wrong. So we think that one of the most significant things that's going to happen that I hadn't fully anticipated or realized before the existence of our court is the development of family law in a consistent manner throughout the state. One other thing I'll say about the family law judges that I've found since being in this job for 16 months, and we had one of our clerks at our court go through the family law section, and there is a tremendous amount of the legislature, you guys have laid out to family law judges a tremendous number of areas where they're to make specific findings of fact. And they're supposed to define cases in a specific way, not to make decisions. But we want you to have these findings of fact and these conclusions of law. And it's probably one of the more extensive areas of law where those requirements are there. But our family law judges are the level of judges that have no assistance from law clerks. So it becomes difficult for them, we've found, to fulfill all those rightfully set. And I'm not critical of the requirements in legislation at all. That's not my point. The family law judges have a very tough job to do. They're placed in a very challenging situation. And we think having a consistent body of law developed at the statewide level that's authoritative is only going to make those decisions better and more consistent the longer we're in existence. So I think 20, 30 years from now, when we look back, I think that may be hopefully one of the more significant things that we've seen develop out of our family, out of our ICA and intermediate court system. One of the other things we've done, the Supreme Court had different programs that they'd established. They often go to the West Virginia College of Law to argue cases. They also this fall went to Marshall University to argue cases. They also have a program called the Laws Program where they go to high schools throughout the state and argue a couple of cases and give high school students an opportunity to see that. We as a court noticed and decided that our other four-year colleges in the state weren't getting that same opportunity. So we started a program we call ICA on campus, where we're going to go around to the different, starting with the public four-year colleges, and argue cases with a goal of once per term, arguing cases there and giving those students at those colleges the opportunity to see our judicial system in action. We started that out at Concord. If you wonder why we went to Concord, by tradition in the Supreme Court, the chief judge gets to select the location of the laws program. So we decided that was a good idea. We gave the chief judge the authority to pick a college. And my son graduated at Concord last spring, so we started out at Concord. So not Prague, that's where we went. But there's a photograph there. That was an excellent experience for us. We got to meet with multiples of students. We actually, all three got to go and talk to classes in the weeks leading up to that. I got to meet with students there. I got to have a question and answer session with them afterwards, not about the specific cases, but just about the process and about the judicial system. And so we think that is a tremendous program that we plan to continue. And upcoming Chief Judge Scar will get to decide where we go in the spring and fall term. Just some conclusions that I've reached after 16 months about our intermediate court. I think we've been able, to some degree, to give some docket relief to the Supreme Court and the circuit courts, even more so at the circuit court level, I think, in the Supreme Court. I do think it's tremendously important that we're able to take some of the workload off of our burdened circuit court system. And again, the development of common law and the family law and administrative law area, I think is going to be important to West Virginia moving forward. And as we mentioned, rightfully so, one of the concerns about our court in the many years that it was discussed before it was created was the problem of extra time and expense for litigants for an extra layer of review. And that is truly a real issue. One of the things I think it is important to recognize that only exists in 31% of our cases. And if you take our 17% appeal rate, it would only exist if that case is appealed from us to the Supreme Court. So when you do that math, that comes out to about 5.25%. So that problem truly exists in about 5.25% of the cases that we hear. But that right now is the amount of cases where that concern does truly exist, and people will have additional time and expense in their appeals. This isn't the Finance Committee, but I would note that all of the budget requests for our court, and this is the Supreme Court that handles this, and we may get our input, but they're the ones ultimately responsible for submitting the budget. But I know they felt very strongly that all of the budget requests that they make with respect to our court have been at and below the amount that was listed in the fiscal note. So we've all seen government programs where the fiscal note is at one level and the actual cost is multiples higher. The Supreme Court has been adamant that their budget request for our court is at or below what was indicated in the fiscal notes. And they've been able to do that so far, and I anticipate that trend continue. So that's just sort of some of the information about what we've been doing. I hope it's been informative to you, and I'd be happy to answer any questions you may have.
Thank you, Judge. Mr. Chairman?
Thank you, Mr. Chairman. Judge, thank you for being here. A couple observations, if I may, and then a question. First observation related to your comments about appeals from family courts. I underestimated the degree to which, as it turns out, I think an intermediate appellate court is going to be transformative in the area of family law. When that court started posting the opinions you posted, I read a number, it hit me, and I hadn't really thought about it, but if you're practicing family law, unless you're directly involved in an appeal from the case from family court to circuit court, before you didn't know about it. You didn't know about the opinion, you didn't know what it said, and as you said, it might be totally different in one circuit from another circuit. And so that's my first observation. I think where the intermediate appellate court is going to crack in the way of a body of jurisprudence for family court is going to be transformative in West Virginia. I really do. And so that's number one. Number two, to your point, as we were considering this legislation over the course of a number of years, I was concerned about some of the people who opposed it or were worried about it, articulated, said to me, Charlie, you're making it more expensive. You're just making it more expensive. We're litigants to be in court. They're going to have to go through 2 levels of appeal. And now that I see your numbers, I realize they were wrong. That's not true. The vast majority of cases, apparently, according to these data, that are decided by the intermediate court are not appealed to the Supreme Court. So I think that's fabulous. We're giving people full review on all kinds of cases, still power to appeal to the Supreme Court if they choose to, but to me, I guess you could read a lot of things into a low percentage of appeals, but I think at some level, it must say that litigants, lawyers, are feeling like they're getting a good review and decision out of the intermediate appellate. So that's why you don't have more appeals to the state Supreme Court, and I think that's all a good thing. Third point, it's a question. I should know the answer to this, but I don't. I know the opinions of the intermediate appellate court are all published on the Supreme Court's website. Are they picked up by West Publishing or LexisNexis or Westlaw? Are they being published in that
Yes, they are. All of our opinions wind up on Westlaw Lexis. Our signed opinions are published in the Southeast reports, West Virginia reports, just like Supreme Court opinions. I don't believe that our memorandum opinions get published in that sense, like on Southeast Second and West Virginia reports, that they will be available on Lexis, Westlaw, those kinds of things. They don't get picked up quite as quickly as our signed opinions, but they will be there and will be available for computer research. And going back to the prior comment about the appeals, and I guess I emphasize that low number of appeals from the intermediate court, Supreme Court, is consistent nationwide. One of the things that I learned once I was, that surprised me was how low that number was. If you'd have asked me before I had any involvement in it to guess what that number was, I would have guessed something much larger than what the percentage actually is. My experience in the other states, and I do anticipate that eventually we're going to be in the same percentage that's typically out there.
I just think, it may say many things, but one of the things, to me, it clearly says at some level is, because of the absence of more appeals to the Supreme Court, the litigants have full review by an appellate court, and at some level must have decided that it's not worth pursuing through another appeal. And to me, that is evidence that counters some of the arguments or concerns that were raised about it when we would consider whether or not to create it. Thank you, Chairman.
Thank you. Yes, sir.
Delegate from. You can take
You,
it over.
you go ahead. I apologize. I used to be the
Juxtaposition.
I used to be the majority up here. I apologize.
Delegate from Jackson.
Thank you. Judge, thanks for being here. So this is 16th month, and you said we're only stating like us, the way we set it up, it was Nevada, sort of. Everybody else is different. Do you think we got it right, or do you think we need to do a few changes and make it even better way it's going? Well, it sounds like it's really working, but do you think we do anything to make it better?
There's not anything that jumps to mind. I mean, as I emphasized earlier, we recognize that we are entirely a creation of the legislature. So whatever jurisdiction or whatever types of cases the legislature feels that we should have, we're happy to take that on. So not really looking to reinvent the wheel or anything like that. And Keith Hoover's over here probably ready. He's watching me here, so make sure he doesn't throw a book at me or something. But just in terms of issues that I think are going to have to be sorted out, whether it's done by the court system or the legislature, one of the areas of our jurisdiction that this legislature made a decision is that in the main section of our code dealt with extraordinary remedies. And we were not given jurisdiction over extraordinary remedies, and it refers to the statute 5311 at SEEK, and that deals with mandamus and prohibition. One of the issues that we're wrestling with, and will have to be sorted out one way or another, is when you go down through chapter 53, there's all kinds of other extraordinary remedies, and one of those is injunctions. And so what we're going to have to struggle with is often civil cases, there's a case for damages, and then there's a case for an injunction as well. If it's like a property dispute, there might be a claim for injunction or damages and a claim, hey, don't let this person come on my property again or something like that. And either the court system or the legislature is going to have to sort through whether any cases that have any mention of this extraordinary remedy like an injunction, whether that avoids us entirely, whether it goes to the Supreme Court. As members of the court, we've heard groups of lawyers that are discussing our court, say to plead yourself out of the intermediate court, maybe plead in an injunction. So that's an area that's going to have to be sorted out, and whether the legislature wants to weigh into that or whether that works its way through the court system, that's another. And please, with all this, that answer and my next, this is Dave Greer talking. I'm not speaking for the Supreme Court. I'm not even speaking for the intermediate court. This is just me as a citizen basically expressing my opinion. And this next one is truly my opinion. One of the areas where we specifically have no jurisdiction majority of the time is interlocutory appeals. And that means an appeal in the middle of the case before it's over. There are certain circumstances where that can happen, and under the current legislation, those all go to the Supreme Court. The only exception is with the new 50/50 custody law, that if there's a temporary order regarding 50/50, that comes to us in the middle of the case. That's the only exception to that. Just personally, as an argument, beyond that, I see an argument that in a regular civil case, for example, if there's some issue that comes up where an interlocutory appeal might be appropriate, and the appeal of the whole case is eventually going to come to us, to me, I can make a logical argument that it might be a better decision to have the interlocutory appeal come to us as well, because we're going to be getting the whole thing at the end of it. But that is, if that is not changed, that's fine. It's not that that's a problem or anything, but that's just something that logically, I think I can make a good argument that maybe if there are going to be interlocutory appeals, they should go to the court that's eventually going to get the case, if that makes sense.
Thank you, Chairman.
I have the delegate from Canal next. How about Chairman?
Thank you. Hello, Judge, how are you doing?
Great. How are you?
Well, just a little bit of feedback to follow up on the chairman's comment. I can tell you that based on my experience, and I've done a lot of family court over the years, and I still do some, it's evident to me that it's been incredibly helpful. So, for example, 4 or 5 years ago, somebody would come to me with a scenario, and I would have to advise them that, well, look, the law's not clear on that particular issue. And because of that, I don't know how, I can't give you a clear answer. It could go one of two depending on the judge. Whereas now, because of a lot of these decisions that we've gotten, there is a lot more clarity. And I think one of the positive things about the development of this law in family court is the idea and the fact that I think it's saving litigants a lot of money. I mean, especially in family court. The fact that there's this clarity in the law, or there's growing clarity in the law, I think that's incredibly helpful for those of us who are practitioners in family law. So I think that's something that's really, really positive. A question I have for you on an unrelated point is, have you got any feedback on the e-file system? I mean, I find it to be fairly easy to use. Have you got any feedback one way or the other on that, and what people think about it?
We've gotten all manner of feedback on the e-files, and thankfully, I'm not the one that has to hear that. Our clerk of our court does, and then I just get that secondhand. But I think generally the reception to that has been positive. I mean, there's been some hiccups and some issues that have to be addressed. The majority of the feedback has been quite positive, and I think generally it's viewed as a lot more efficient than the old days where you had to print out all the copies of your briefs and get them in there, and just being able to file them electronically. I think the vast majority of the people have been happy with that, although there's been some negative experiences as well. I don't want to minimize that, but I had to characterize the feedback overall as being positive.
Well, from what I've encountered with some less than technologically savvy attorneys that I know, to the extent that there has been any kind of problems, I mean, I think that the practice of the court at this point is maybe cut people a little bit slack if something's like,
Oh, yeah, absolutely. Absolutely.
And I think that's really, really
Yeah.
a good thing. And I think for a lot of those attorneys, I think they would have to continue at least until they get used to the technology.
Yeah, absolutely. Absolutely.
Mr. Chairman?
Thank you, Mr. Chairman. Following up on your point, Judge Greer, now your disclaimer was you didn't speak for the whole court. I don't speak for anybody here other than me, not even the Senate Judiciary Committee, but it never would have occurred to me as we were considering the legislation that injunctive relief, which I consider to be equitable relief, could ever be characterized as extraordinary legal relief. In other words, for me personally, when we were considering that bill and acting on it, I don't know whether the court has ever had the rule to make that determination yet. Is it equitable relief or is it extraordinary legal relief? But it would never would have occurred to me that an appeal of a civil case that involved an injunction could not go to the intermediate court.
Yeah, that in fact argument is being made, and it's something that'll have to be, that's a legal question that will have to be sorted out by someone.
Well, alert us if there's a decision on that that's positive. That's something that don't know, we run up a flagpole during the session and see if we want to clarify that by statute, it needs to be clarified. But to me, injunctive relief is equitable relief, not extraordinary legal relief.
Delegate Moore.
Judge, thank you for being here.
Thank you.
Obviously, I've asked you questions given our.
Sure. I'd have been disappointed if you hadn't.
So, I just had a few questions based on the numbers and representations that you made. First off, how long does it take you for the court to render a decision once an appeal to the ICA is made?
It depends on the type of case, and I've got some time frames because I anticipated that question. Part of that answer depends on how fast the attorneys perfect their appeal, and there's different time frames for that depending on the type of case. The short answer, a shorter answer, on family law, typically the time period from the judge's order until that case is ready for our consideration is typically about 85 days. So after the 85 days, that then goes to we're built just like the Supreme Court. We have an office of counsel that takes the first look at it. They give us a recommendation. We decide whether we're going to argue it or decide on a memorandum decision. If it's a memorandum decision, literally probably within 30 days after the 85, we might have a decision. So that would be, 115? If it's going to be orally argued, you're probably going to add 2 or 3 months to that because we have to set the oral argument, then we have to write the opinion. For common appeals, the initial time frame is 80 days, and then the same time frame would go from there. For civil, it's our longest duration. It's about 205 days. All of those days can be shortened. For example, if the attorneys don't wait till the last day to file either their appellate brief or the response brief or the reply brief, every day or week that the attorneys beat those deadlines, that would shorten our time frame for a decision by that amount of time. Now, obviously, we, like every other court, aren't perfect in getting to decisions immediately after that, but we are trying to stay as current on being able to deal with cases as soon as they become mature at our next conference as much as we can, and so far we've done a pretty good job of doing it.
And based on some of the numbers I represented, 84 cases of peers have been appealed to the Supreme Court, which is roughly 19% appeal rate. But I'm not finding it here in your testimony. What percentage of those cases are civil?
I did not do a breakdown of that. I didn't go in and do a percentage-wise, so I haven't checked if the percentage of appeals are identical to our overall caseload or not. So I can't, it's 31% of our overall caseload is civil. I cannot represent to you, and I have not studied those numbers to see whether, I can try to do that and get you that number, but I just haven't looked through those 84 to see where those are coming from.
Could you provide that for
I will try to do that, yes.
You don't have a hunch based on the 84, if it's half or more than half of this?
I really don't. I don't know. I haven't, I would, my guess is that it's probably a little bit different than the overall percentages just because the types of cases seem to dictate how they go in different ways, but I really wouldn't want to speculate without just looking at those exact numbers, but I'll try to get you that information.
And you mentioned that the Supreme Court is kind of responsible for the numbers related to the budget, but I didn't hear any numbers that were expressed. Do you recall what the budget is for the intermediate court?
Off the top of my head, I don't. I know that, and it depends on, I mean, there's a lot of different ways to look at that. There's the outright numbers, and then there's the numbers when you deduct the expense from the office of judges and those kinds of things. So I know that the startup year was greater than the following years, but I mean, it's in the millions of dollars. Whether that, I mean, it's less than 5 million. Whether that's 2, 2.5, or 4, I don't recall as I'm here today.
And just so we're clear, obviously some of us here are practitioners, but the public's also listening in. Can you just give us a breakdown on how often the court meets and the requirements associated with that? And we have obviously some meetings that took place in universities, but just a schedule of the court, how often it meets, just so the public's aware, because it's new to everybody.
Sure, we have terms just like the Supreme Court. Our terms are largely identical to the Supreme Court. In this fall term that we're in currently right now, the Supreme Court went signing die last Thursday. We're going signing die this coming Thursday, so we extended it a week longer than that. In our fall term, throughout our term that started after Labor Day and ended, it will end this Thursday. I think we scheduled somewhere between 8 and 10 oral argument days to argue I think I said 27 cases that we chose for oral argument. Those calendars are posted on our website. You can go on the Supreme Court website, there's a section for Supreme Court and a section for ICA, and you can go on those links and they'll give you the dates of all the arguments. And there are webcasts, so anybody in the state of West Virginia can go on those days of the argument if they see a case they're interested in and sit there and watch. Certainly they're open to the public and you can always come in and do it. But all of those schedules are posted on our website.
Again, for the public that's listening, and when you say this fancy term like signing die, what do you mean by that?
That's just when our term is over. It's like at the end of the 60-day session. When the term is over, the same thing, we have our terms of court. We do all our work within our terms. And when we end our terms, then our work is done until the next term starts. Our spring term will start, I can't remember if it's January 2nd or 3rd, but right after the first of the year, we'll be back in session in our spring term.
So when you return signing die and the work is done, you said, is the court judges in a meeting or anybody?
Yes. What we're doing after we go signing die is we will start case conferences for the next term of court. We will, in December, we have conferences scheduled where we're going over the next stack of cases and deciding whether those are going to be placed on oral arguments in the spring term or whether we're going to decide those based on memorandum decisions. So the work continues, we're just not here for oral arguments. Thank you.
Senator from Marion.
Thank you, Mr. Chairman. Dan, it's great to see you, as always. I kind of miss you running around the chamber. I got a couple non-work questions.
Sure.
On the cases that were disposed of, you have listed 154 cases, and I like this for some example, because I really don't know what this means. Failure to perfect appeal and lack of subject matter jurisdiction.
Sure.
Just in a non-lawyer's.
Sure. Lack of subject matter jurisdiction is the easiest one of those. And for instance, we have no criminal jurisdiction. I mean, we don't take criminal cases. We have had instances where either individuals or lawyers that just didn't understand it, didn't file a criminal appeal in our court. That gets immediately dismissed because we have no jurisdiction to hear a criminal appeal. But because it was filed, that goes down as a case filed in our court, but it's immediately dismissed. Also, like the extraordinary remedies, like if somebody filed an appeal of a writ of mandamus with our court, we have no ability to hear that case. That would immediately be dismissed. Failure to perfect an appeal, take an ordinary civil case. You have 30 days to file a notice of appeal for the entry of the judge's order and say that's filed, so the case is filed and present with us. And then you typically have 4 months, can be extended up to 6 months, to file your brief that presents your legal arguments of why your appeal should be granted. We have cases where people file their notice of appeal and then they just never file the brief for whatever reason that actually presents the legal argument. And what our clerk does in those cases is they'll send out a notice of intent to dismiss and say, hey Senator Caputo, you haven't filed your brief. If you really want this appeal heard, you have to file your brief. And if there's no response and nothing's ever filed, that will be dismissed because they didn't meet their deadline to file their appeal.
Thank you.
And filing that brief is what's called perfecting the appeal.
That's very helpful to me. Thank you.
Thank you.
And then I want to talk to you a little bit about workers' comp decisions. Did you go back any further in 2021? I see your decisions reflect the board review in 2021, but did you go back?
I did not. We got that information from the board of review. That's information we got internally from them. I didn't do that. That was a statistic they had published, and the only year that I found that they had published was 21. They may be available for prior years, but I didn't. I saw that one and didn't see others.
Yeah, I was curious.
Yeah.
But just for clarification, so someone files a workers' comp claim, the company denies it for whatever reason, that's what comes before you, right? To see if the injured worker's claim was properly denied.
Correct, or the opposite, if a claim is granted and the company appeals saying you shouldn't have granted it, both are absolutely correct. I mean, we get both of those types of.
So how is it broken down though? I've got to assume that there's probably more challenges from the company side than there is, from the workers. Oh, I'm sorry. I have to assume the worker is challenging it more where he or she was denied that. Am I correct?
I'm not sure that I would agree with that. Like the question from the delegate, I haven't looked at those statistics, but anecdotally, I would say it's fairly close in terms of whether the injured individual is complaining or whether the company is complaining.
Well, I'd be curious to know if you could get back to me on this 86% number. Was that 86% of the time that the decision came in favor of the worker or against the worker?
It says nothing about that. What that says is that whatever the decision the board of review sent to us, we affirmed that 86% of the time. If they ruled in favor of the worker, 86% of the time we affirmed that ruling in favor. If they had ruled in favor of the company, 86% of the time, whichever way they ruled,
You just
affirm that. And again, the reason that is as an appellate court, there's what's called standard of review. How do you look at the questions presented? On factual questions, if there's a dispute about a fact, we are very deferential to the court or the in this case, the board of review below. If they find a certain, they're the ones that heard the evidence. If they believe one party over another, we defer to that unless we look at it and say, you guys really messed that up. That's why that number tends to be higher, because most of the comp cases are fact-based versus some question of law and how, because that's in comp, that's been fairly well fleshed out over the years and through statute, so there's not as many questions of law in comp cases as there are civil cases or family law cases.
So before the ICA, these cases went straight to the Supreme Court?
No, the first level, after privatization, the first level of decision is always by a claims administrator, either for an insurance company or a self-insured employer. Before the ICA, they then went to the Office of Judges, and they either affirmed or reversed the claims administrator decision. After that, the first appeal was then to the Board of Review. After the Board of Review, they then went to the Supreme Court. Now it goes from the claim administrator to the Board of Review. That's the first sort of litigated area of dispute. It's brand new there. Everybody presents their evidence, and the Board of Review just makes a decision about the disputed facts and law. Now the appeal comes from the Board of Review to us, and then to the Supreme Court.
Okay, thank you, Judge.
Thank you. Thank you, Senator.
It's good to see you.
It's good to see you.
Further questions? Further questions? Yes, Senator from Carolina.
Thank you, Mr. Chairman. Since this is the last question, just a little bit later, the gentleman from Woburn said the proper remember this too. So to the judge, we sat together long ago, far away, and wrote just like this. As a matter of fact, I sat in the same chair I'm sitting here, so I had and you sat beside me. And as freshman delegates, on every bill we tried to amend. And we raised so much pain, it's unbelievable. Rick's taking notes. You gonna let me do that in your court?
No.
So things haven't changed for me. That's right. Thank you, Mr.
Further questions? Further questions? All right, the chair will recognize the co-chairman. For a motion, if there's no other further business, is there further business?
Mr. Chairman, I move we adjourn.
Motion is on adjournment. All those in favor, please say aye. Aye. Mr. Carroll, you see, I say aye.